हुई, रिजर्वेशन की बात हुई, तो पुणे पैक्ट 1932 clause 7 says if there will be any change in the reservation or representation system, then both party will sit and consider the negotiation and the terms of this agreement. But it's not like that in nowadays, because Supreme Court is not behaving as a law interpreter. Supreme Court is behaving as a law making agency, and that is totally arbitrary and dictatorship in the constitutional system. But now I would like to call Vivek. Give your views, Vivek.
Good evening, one and all present here. I take immense pleasure to welcome all the dignitaries on the dais and off the dais. Before I start, I would like to thank my senior Advocate Lenin sir for giving me such a wonderful opportunity to be part of it here. I wish to start my discussion with a well-known saying, justice denied is justice delayed. In Indian judiciary, the major challenge is pendency of cases. Based on the latest report of Ministry of Law and Justice, 49 lakhs cases pending in all the high courts of India. The main reason for this pendency is vacancy of judges in high courts. Based on the report submitted by the Department of Justice, the sanctioned strength of the High Court judges is 1079. In that, 771 judges are permanent judges and 308 judges are additional judges. But the vacancies as on 1st March 2019 are 394. The reason behind these huge vacancies is undue delay in appointing High Court judges due to collegium system. Collegium takes lot of time to send recommendation to central government, and the central government sometimes takes months to decide the recommendation of collegium, and we do not know how the collegium selects the judges of high courts and supreme courts. This whole process of selecting of high court judges and supreme court judges is surrounded by smoke of secrecy. We all know that how the collegium system has been evolved from S.B. Gupta case to 4th judge's case. In 4th judge's case, Justice Chellameswar clearly stated in his dissenting opinion the defects in collegium system, and he accepts the flaws in the stem and the lack of transparency in the appointment process. And I want to tell you this, the higher judiciary has exempted itself from the Right to Information Act. The lack of transparency has caused significant distortion in the functioning of India's whole judiciary system. The collegium itself could not come to consensus in allocation of cases among themselves. It became evident in Judge Loya's case and subsequent unprecedented press conference held by 4 senior most judges in January 2018. So, if the whole process of appointment of High Court judges and Supreme Court judges exclusively given to collegium, it can't be infallible. I want to say something. The UPSC conducts civil service examination annually and appoint officers in a time-bound manner. Likewise, if All India Judicial Service is created, it will ensure that transparency in the process of appointment of judges. Hence, All India Judicial Service shall be the only alternate to appointment judges. Thank you.